Thank you. Well, good afternoon, Arizona Wild. I am Erin Lageson, and I am the presiding judge of Department 3 of the Oregon Court of Appeals.
Good afternoon. My name's Doreen Hartwell, and I am an attorney in Las Vegas, Nevada.
And I'm Steve Jewett. I'm a county court judge in Orange County, Florida, on the Ninth Judicial Circuit, and that's Orlando.
Students, would you please introduce yourselves?
Hi, my name is Shrika Kantala.
Hi, I'm Manvi Harde.
Hello, I'm Michael Chen. Our coach is Brianna Willits, and thank you all for being here today.
All right, let's get going. As you know, we have our question 2 today, which goes as follows. It starts with the quote from Thomas Jefferson. A Bill of Rights is what the people are entitled to against every government on earth, general or particular, and what no just government should refuse or rest on inference. Do you agree or disagree with Thomas Jefferson? What are the advantages and disadvantages of a national Bill of Rights as compared to state bills of rights? And finally, what are the differences between positive and negative rights, and which are more important to the preservation of liberty? It's your time.
Natural rights are rights that people possess in the absence of government. Under the social contract theory, people give up some of these rights to form a government, but the rights retained deserve the greatest protection.
Many colonists felt that the British infringed upon natural right with actions such as the Quartering Act of 1774. The framers sought to protect these rights, but a debate arose as the Anti-Federalists supported a federal Bill of Rights while the Federalists opposed one.
I agree with Thomas Jefferson because the federal government can infringe upon people's rights without a written Bill of Rights. In Brutus 1 and 2, the Anti-Federalists argue that the elastic and supremacy clauses of Articles 1 and 6 give the federal government too much power, concentrating it in the hands of a few and eliminating individual rights protections.
I disagree, as written bills of rights are too restrictive. As Hamilton argues in Federalist 84, essential rights are enumerated in the Constitution, and other provisions such as checks and balances safeguard against abuses of power. Furthermore, the Federalists argued that the preamble to the Constitution protected rights better than any Bill of Rights could.
National Bill of Rights grant the federal government sufficient power to protect the people. In Federalist 42, Madison claims that the central government must possess considerable powers to rule a nation cohesively. To improve over the Articles of Confederation, the new government needed more power and strict definitions for the people's rights.
However, a national Bill of Rights restricts states' rights. The Supremacy Clause of Article 6, Section 2 elevates the Constitution and pursuant laws. Moreover, while the 10th Amendment initially delegated states' rights if the federal government was not enumerated, the 14th Amendment's incorporation doctrine renders this completely moot, as federal laws can simply be applied to the states.
Thus, one advantage of state bills of rights is that they maintain states' powers and respond to the people directly. Every state constitution contains a Bill of Rights, or, as in Arizona, a Declaration of Rights. These declarations of rights sometimes outdate the Constitution itself, with Virginia's coming from 1776, demonstrating a long-founded emphasis on state power.
Nevertheless, some may argue that state Bill of Rights violate the rule of law. Under this concept, almost all people must follow the law equally, nearly impossible if rights differ in each state. The lack of a national Bill of Rights also violates the Equal Protection Clause of the 14th Amendment, which ensures that all American people are treated equally.
Most rights are construed as either positive or negative rights. Positive rights require the government to actively protect them, such as the Sixth Amendment right to a speedy and public trial, while negative rights prevent government infringement, such as the Fourth Amendment right that the right of the people to be secure shall not be violated.
Positive rights preserve liberty by requiring the government to provide people their rights. This concept is consistent with John Locke's social contract. Since the people trade some of their natural rights to live under a government, the government must actively protect the rest.
However, negative rights are truly essential to the preservation of liberty. They restrict the government from overexpansion and provide more clarity than positive rights in terms of the government's burden in establishing them. Indeed, all but the Sixth and Seventh Amendment in the Bill of Rights are negative rights, demonstrating that individual liberties are truly supported only under a limited government.
With predecessors such as the English Bill of Rights of 1689, the Federal Constitutional Bill of Rights lists the people's fundamental rights, an essential facet of American government. However, many often debate whether it is as effective as individual state Bill of Rights, as well as whether rights are more beneficial when designated positively or negatively.
Thank you. So for your first follow-up, what limits, if any, should be placed on the rights listed in the National Bill of Rights?
So we see that the National Bill of Rights is just the first 10 amendments to the Constitution, right? And over time, some of these amendments have become out of touch with the time. So for instance, the Third Amendment against quartering, right? At the time, the framers did worry about quartering. After all, the British had just shoved their soldiers into American homes, and thus this was a valid issue. However, now this is not really an issue, and we see that because of that, we have things like the Third, the Fifth, and the Seventh Amendment have not been incorporated to the states. That is, they are not forced to be applied to the states because they are simply not relevant to the American people. So one of the restrictions that should be placed on the Federal Bill of Rights is that we should focus on the 10th Amendment, that the states really get rights to determine what's happening. And we see it in the case Bond v. US, right? When the Supreme Court ruled that people could challenge convictions in federal courts under state statutes because the states are really what make up the Union and the United States of America.
Additionally, as we can see in the FISA courts, and what the Bill of Rights is not doing to protect the individual people's liberties, with the FISA courts, basically the overall idea is that the US government is supposedly getting information from foreign surveillance, but they're actually pinpointing American citizens and their personal information from cell phone history, computer history, and the Bill of Rights or the Supreme Court has not officially said anything is wrong with this being done in the FISA courts. So more than limits, I think we need a regulation or a push for action for Supreme Courts to use the Fourth Amendment in making sure that there needs to be a warrant for the FISA courts to be able to push into Americans' personal information through their cell phone history and computer histories.
I also stand by the fact that the National Bill of Rights should not have any more restrictions, but should be expanded, as we can see with the Magna Carta and how that originated from the fact that the sentiment that the Bill of Rights were agreements between the kings and the subjects, and therefore the Bill of Rights were essentially restricting the king's power. And therefore, with that, original sentiment with the Magna Carta and what our own Constitution is kind of inspired by, it should be expressed in our Constitution as well, with more bills of rights protecting more of the citizens' rights and limiting the governments, or with the British aspect, the kings.
Maybe I misunderstood, but I thought I heard in your prepared statement that you had indicated that the state's Bill of Rights, if a state has a Bill of Rights, that it may violate the rule of law. Did I hear that right? It was in one of your prepared statements. In what way? So I assumed that by that statement that you would then be not in favor of the states having their own, each state having their own Bill of Rights. Is that safe to say as a panel?
So we believe that since bills of rights in states can be so different, they don't necessarily reflect the best wishes of the people. So for instance, every state constitution has some sort of a Bill of Rights or a Declaration of Rights. In Arizona, Article 2 is the Arizona Declaration of Rights for the Arizona Constitution, and it contains 37 rights. And some of these rights go into very specific ideas, such as water rights, right? And because of this, we see that under federal law, some of these bills of rights, some of these rights outlined in state constitutions may violate federal law, especially due to the fact that the Supremacy Clause and the Commerce Clause do allow the federal government to regulate significant amounts of state activities. In New York v. US, the Supreme Court found that Congress could require states to have different burial site requirements for low-level radioactive waste. And we see that under state laws in New York and Pennsylvania, there were appeals against this because they violated federal law.
Well, when that clashes and comes up, who wins? Does the state Bill of Rights, or does the federal Bill of Rights?
When looking at state Bill of Rights versus federal Bill of Rights, we can also look at the 10th Amendment in giving back the rights to the states. However, states can carry out processes such as interposition and nullification if they do not believe in federal statutes. And although the states do have rights guaranteed to them by the Bill of Rights and the 10th Amendment, sometimes the states they do not tend to abuse this power, but it's very disorganized. And as Michael mentioned, different states have different priorities in their Bill of Rights. So if we were to focus on the individual states' Bill of Rights, then our country would not be able to come to a common consensus or decision on federal courts or federal issues or stuff that can really impact the common good in a negative way.
Furthermore, as my previous teammate mentioned, in regards to criminal cases, in Abdul Kabir versus v. Quarterman, we see that Texas's special issue jury instructions for capital sentencing in regards to a kind of the individual's backgrounds in terms of their mental health or any mental defects, and the Texas essentially had mentioned that that should not be considered in Supreme Court in their case. However, the Supreme Court ruled that this was not constitutional as required by the 8th Amendment, and therefore the Supreme Court ruled that the National Bill of Rights takes precedent over these Texas State Bill of Rights.
What poignant example of this happening with the 4th Amendment, right? So it protects us against unreasonable searches and seizures. So in 2017, the Supreme Court ruled that the federal government didn't need warrants to access, say, cell phone histories or search histories, right? But in Arizona, the state of Arizona v. William Mixton in 2019 ruled the opposite, that police did not necessarily need warrants, that as long as they had some suspicion, a reasonable suspicion of a crime, that they could just access search histories indiscriminately. And we see that even though the exclusionary rule can be violated in certain cases, that the ruling in Arizona is very dangerous because it allows the government to infringe upon the privacy rights of the people, an implied right under the 9th Amendment.
What circumstances, if any, would cause a person to lose rights found in the Bill of Rights?
Circumstances where individuals, so your question is, in what circumstance would individuals not be able to have their rights protected under the Bill of Rights?
That they actually lose their rights under the Bill of Rights.
So a common example of this would be if the individual was inherently harming the common good. If an individual, say the First Amendment, was practicing their right to free speech, but this free speech, if it goes through liberal, or if it's like if the free speech actually harms the common good, and that is an example of individuals that should not have the protection of free speech with the First Amendment.
Okay, thank you.
Thank you. Great job, Arizona Wild. I really enjoyed listening to your presentation and our time with the follow-ups. I sort of liked how you located this discussion in the historical discussion and the debate about having the Bill of Rights or not having the Bill of Rights. You took a pretty firm position as to agreeing with Thomas Jefferson on that. Your statements about state bills of rights conflicting with the rule of law or possibly violated equal protection is something I'm going to have to think about more. That was a new idea. I'm glad that Steve explored that further with you, and I think I'm coming to a greater understanding of your perspective of that. I also thought it was your own knowledge of you're coming from a state where we have a Supreme Court that interprets our state constitution to provide much higher level of protections than the federal constitution. It's very interesting to hear about Arizona perhaps going the different direction, and which demonstrates, I think, the value of both constitutions, perhaps. Great job, guys.
Yeah, that's kind of the interplay that I was interested in, because that's really kind of what today it's been sort of my focus is state versus federal, and when there's a conflict there. And it's interesting when you talk about that, you know, if you have a state constitution that is more restrictive, then obviously, you know, then you do have that, you're all right, that's a problem. The state of Florida, we actually have a right to privacy that's contained in that was an amendment that was added. So we have some things that other places don't have. And so generally the situation is that our state constitution gives more rights than the federal constitution. And of course, in that situation, you can give more, you just can't give less. That's the, you know, seems like they need to challenge some of the stuff in Arizona. Overall, I did enjoy it. I liked your opening statement. You had a position and you took it, and then when I challenged you on a little bit of that, you still were, you still bounced back and had an answer for it. One thing that I didn't get to that I had written down though was, and again, maybe I misheard it, but you had indicated the Fifth Amendment is not relevant. I'm not so sure that, maybe I misheard that, because if that was the case, I think that the Fifth Amendment is still fairly relevant in most places, I think so. But at any rate, good job, way to go.
Yeah, good job. I echo the comments of my co-judges. I thought your prepared remarks were well done. You definitely answered the question, and you had historical references in there. You had some cases, and for the most part, you were really clear with regards to positive rights versus negative rights, the advantages of a national Bill of Rights and so forth. And we did run out of time, because I would have loved to have asked more about your statement with regards to the preamble of the Constitution protects individual rights better than any Bill of Rights could, following up on Hamilton's argument with regards to that. But we ran out of time. And I thought too, I just wanted to comment on with regards to your prepared remarks. I thought all of you delivered them really well. You all were animated. And it was a pleasure and a joy to watch. It wasn't just you reading off of, you know, your computer or whatever. So I thought that was well done too. So good job and good luck.
Thank you.
Thank you.